Hello, my name is Paul Maier, a barrister at law candidate at the Honorable Society of King's Inns, and this is my submission to the Employment Law Association of Ireland Student Competition 2022. The topic of the submission is how should employment law change to ensure flexible working and the right to disconnect in a talent-driven market? To answer that question, I'll first talk about the story of Orla, who represents that talent-driven market in Ireland today. I'll talk about some ideas that Orla and people like her have for discharging their work in a more flexible way, in a way that better suits the new ways of working today, and the legal problems that arise from such a proposal. I'll then talk about the changes in employment law which would facilitate and improve these ways of working. And finally, I'll address their effect on Orla herself and people like her. Orla represents many people, but in her particular circumstance, she's 33 years old. She has a husband and a young child who's 10 months old. She's an account manager in financial services, and she's enjoyed working from home. That is until she went on maternity leave last year. And her husband works in healthcare, which means she's had a lot of responsibilities at home, not only with her newborn daughter, but also with her parents and his parents, who are both a bit elderly and can't get along as well as they typically would. There are offers available to Orla when she goes back to work in a few weeks to change employer for about 10 grand more per year. But money isn't the only thing which is important to her. Flexibility is as well, and the ability to meet her responsibilities as both a parent, a caregiver, and as a person in her own right as well. To do that, she has an idea. She wants to split up the work week and indeed the work day a little bit more than would typically be the case. Prior to the pandemic, and even during the pandemic, Orla worked 9 to 5, Monday to Friday. The only difference being that when she was working from home, she discharged those hours while she was at home. That's going to be a problem for her, however, when she goes back to work in a few weeks, because she has to pick up her 10-month-old daughter, Krista, at 3 p.m. every day. And after that, she'd like to spend a bit of time with her as well as spend time with her family. That's going to mean, if she stays with her employer and doesn't do anything else, that she's going to be paid for 2 fewer hours every single week, or every single day for that matter, and a total of 10 fewer hours in the week, a 25% decrease. And based on what other people have said in her office, that shouldn't be a problem, but she will get a decrease of proportional amount of money on her annual salary. Doesn't seem very fair to her because those hours of 3 to 5 are probably the least productive she feels in the entire day for her. So she's got a better idea. She'd like to work from 9 to 3, yes, and she'd like to pick up her daughter and take care of things around the house and with her family and all of that. But she'd like to make up those 2 hours at 2 distinct points during the day. One from the period of 6:45 to 7:45 a.m. After she's woken up by her daughter and before she has breakfast and goes off for the day. And a second period from 7 to 8 p.m. when Krista goes to bed and she has a bit of time to relax, take care of things, things that would require a little bit more deep thinking and a little bit less communication with her colleagues. The difficulty is that she's got a lot of questions. Is she entitled to make a request? Is this pattern even possible or legal? And how would it be monitored? And I think most importantly to her, she's off work from 3 to 5 p.m. Is that going to be respected by her employer and colleagues? With regard to the first question, the right to request, the answer is, of course, you can request anything you like, but her employer is under no obligation to consider it seriously or otherwise. If it's an idea which is novel, unique, or anything else, it might just be rejected. And the employer has no obligation to provide reasons for such a rejection. But even if, in this tight labor market, it's talent driven, maybe they want to make this work, they'll run into some challenges with regard to the Organizational Working Time Act 1997. And that's not something to mess with, because not only is it Irish law, it's EU law as well. And it's health and safety legislation, which is put in place to protect workers and make sure that they're not putting themselves in danger by working too much without enough rest. And speaking of rest, that's one of the issues that arises, because Orla wants to stop work at 8 p.m. and rest and then start work again at 6:45 a.m. And although that seems reasonable enough, it's actually only 10 hours and 45 minutes of rest. And Section 11 of the Organization and Working Time Act requires a period of not less than 11 hours consecutive rest. Now, there is a provision under the Organization and Working Time Act for an exception when you're doing work spread out over multiple periods during a day, but case law indicates that that might not be as clear as originally thought. An employer has an obligation to ensure a period of 11 hours rest. And that case law may make Orla's employer a little bit concerned as to whether or not they would be in the right by allowing that to happen. Further, even if that's agreed, there's the difficulty of monitoring work. And this is something that employers have had difficulty with throughout the pandemic. How do we know that people are working? And furthermore, there's an obligation on employers to monitor the hours that employees are working under Section 25 of the Organizational Working Time Act. It requires employers to keep an accurate record of working time every single week, regardless of whether or not that is in correspondence with the actual schedule or not. And that record needs to be kept for a period of 3 years to ensure an inspector can check for compliance with working time regulations. And when it comes to Orla logging in at 6:45 a.m., does she need to make an entry in an Excel spreadsheet? Is it going to be logged automatically? Is that allowed? Is that legal? And even if it were permitted, is that something that Orla really wants? Those questions need guidance, and there are unique ones which haven't been definitively set out in legislation or in guidance just yet. And finally, the entitlement to quiet time. Orla's concerned that if she's logging off at 3 o'clock, is she going to get rung on her mobile time and time again as she has her daughter in the back seat, trying to get her to relax after a fun-filled day at creche. And if the Organization and Working Time Act is applied strictly, she wouldn't have too much to worry about, because she'd only be contacted in exceptional emergency or unusual and unforeseeable circumstances by her employer. However, the WRC Code of Practice on the right to disconnect softens that position a little bit, says that occasional contact outside of hours is permitted, not for emergency circumstances, but where it could really be foreseen. That's tension between Section 5 of the Organization Working Time Act and consequently the directive which implements that provision and the Code of Practice. And that's going to create difficulty for Orla herself when she's trying to determine whether it's worth making this arrangement. She's signing up for additional hours, but if she's going to be called from 3 to 5 anyway, surely she's working during that period. And of course, periods of on-call is a considerable concern in the employment law sphere in Ireland and of course throughout Europe as well. So here are the changes which could be put in place to address these concerns. First, on the EU scale, Ireland needs to transpose and implement into legislation the EU Work-Life Balance Directive, which was put into effect on the 1st of August of 2019, which means that Ireland needs to get that onto the books by the 1st of August 2022. There's some a casual approach to this, perhaps because a lot of the regulations and a lot of the provisions in the Work-Life Balance Directive are in Irish law. But one that isn't is the right to request flexible working provisions, especially if you're a carer for a child or for someone else. This would benefit Orla tremendously and would entitle her to request flexible working arrangements. That is, not only the right to remote working, but also the right to work flexible hours, and for her employer to consider it seriously and to only reject it if there are business reasons for such a rejection. A similar framework is set out in the Right to Remote Working Bill in 2022, which was published recently enough. And while there are criticisms with regard to the reasons being overly broad, it is a step in the right direction that allows Orla, at the very least, to make a good proposal for such flexible working arrangements. Second, Section 4.2 of the Organizational Working Time Act should be clarified to ensure that employees like her can do an hour in the morning, can do an hour in the evening, and still be in compliance with the Organizational Working Time Act. Of course, we need to be careful. Employers can't simply claim that provision on behalf of their employees. In a perfect world, there would be a statutory instrument which clarifies Section 4.2 and provides that the requirement for rest periods, including most importantly consecutive rest per night, can be waived or altered with the provision of compensatory rest under Section 6, where the employee makes an application on their own volition for such an alteration, and where a health and safety evaluation is taken to ensure that that shortened rest period or that variance would not be a danger to themselves or others in the context of health and safety requirements. Third, and very simply, there needs to be clarity on Section 25 Organizational Working Time Act records, both in terms of the requirements and in terms of the enforcement of that law. At present, there's real concern that many employers are not following through with those records. And that's only become worse in the context of remote working, where employers don't really have very good sight on when their employees are working and when they are not. It's an obligation. They need to record those hours. And it may be the case that a technological solution like tracking the activity on work-related hardware, such as a mobile phone or a laptop, may be the best way forward. But that should be decided with employee consultation. The best way to get this done is to have some guidance from the WRC on this issue and to make sure that there is, at the very least, a framework in this area that employers can follow. And speaking of frameworks, finally, the WRC needs to really consider whether the language in the Code of Practice for the right to disconnect is consonant with the Organizational Working Time Act's strict restrictions on contacting an individual or having them work outside of their typical working hours and during their rest periods. It will create tremendous difficulty if Orla has to pick up the phone, and studies have shown throughout the social sciences that such interruptions have the same effect as long working hours in and of themselves. If those changes are put into place, Orla will be entitled to make an application for flexible working hours. She'll be able to apply for her flexible hours, and that'll be under the Organizational Working Time Act, A-OK. She can keep track of her activity through a log that is either recorded by her individually or, with her consent, recorded by her device as she logs onto her computer every day. And those records could be kept locally and only provided to the employer when required. And finally, and most importantly to her, she'll know that she won't get a call outside 9 to 5 unless it's really an emergency if the Code of Practice is tightened and strengthened. Thank you for the opportunity to give this presentation.